I'm providing you this video because you've articulated to me a desire to plead guilty at your next court date in exchange for a plea offer from the prosecutor. This is a common way that cases like this end. In fact, it's how majority cases end. It's important that you understand that as your public defender, I am not hesitant to go to trial. In fact, I do not want you to sign or enter a plea agreement if you are innocent or you have significant grounds for arguing that you should not be convicted. All felony plea agreements are made before a judge, and there'll be 3 people standing before the judge when that happens. You, the defendant, me, your attorney, and the third person will be the prosecuting attorney. The judge wants to understand 3 important things before accepting your plea of guilty. The first is that your plea is being voluntarily and competently made. Specifically, that you are not being coerced into doing it, and that you have the mental capacity and understanding of the facts to competently make the decision. The second thing the judge wants to understand is you understand what rights you have and are giving up by pleading guilty. And you are giving up certain rights. And the third thing is that you understand what you are getting in return. What is the good things you're getting out of this by waiving your rights? To assist the judge in doing this, the judge will have had us complete a 81-paragraph, 9-page plea petition. So it's called a petition to enter a plea of guilty. And in that, there are 81 paragraphs which you initial. There are 3 ways to do this plea petition. The best way would be for you to make an appointment, look at my online calendar, or call or text me, and let's set up a time to meet. We can meet at my office in Farmington, or we can meet at the St. Genevieve Library. And I can answer your questions on any of the 81 paragraphs that are not clear. Truth of the matter is, most of the paragraphs are very clear, and there's really nothing complex about them. Probably you can get through the 81 paragraphs and maybe 5 bring up some question that you may have. And so this video is my attempt to go through each of the 81 paragraphs, allow you to think about them, and if my explanations are not clear, then you can come to court on the day of court and I can answer those questions to maybe those 5 or more paragraphs. The worst outcome would be not looking at this video and just coming to court and trying to do the plea petition on a hectic day with me having 50 clients, maybe 5 of them that want to plead guilty, and a judge who's on a very tight schedule. So it's really important for you to make an appointment with me or to watch this video and going over each of the different paragraphs. Let's start with the petition to enter a plea of guilty. I will confirm that the top is correct with the case name, case number, and division. Let's go through each of the 81 lines. Number 1, I understand that I have the right to remain silent and not to speak or sign any written statement, including this document, and that anything I say or sign may be used against me. This is critical because in order to plead guilty, you have to tell the judge things. You need to sign this document, which states certain facts. You are, by doing so, not remaining silent, and the court needs to know that you are doing so willingly. So after you read this, you can see, number 1, you will circle yes, and you'll initial in that top box, and you see it's a circle and then an arrow down. That means that your initial is valid for every one of these lines, depending on what answer you give. Number 2, I have been told by my lawyer to be truthful in all statements made in this petition and at the plea hearing before the court, and I have done so and will do so. You will be under oath before the court, and as always, I expect you and the court expects you to be truthful. 3, I request that the court use and rely upon all of my statements in this petition in determining whether my plea is knowing and voluntary, and in determining whether or not to accept my plea of guilty. That's the purpose. We're going to the court to say, accept these statements and accept my plea of guilty. Number 4, my full name is, and it should be written in there, but confirm it's correct. Your age is, write that in. Your date of birth, and my highest year of education. Put your last year that you attended school. If you have a GED, put that in there. Number 8, I can read, write, speak, and understand the English language. Cannot read. absolutely not a problem. We'll make sure that I read each and every line, and that's what we're doing here in this video. Number 9, my lawyer's name is Grant R. Doty. That is my bar number. I was previously represented by. If you had a previous attorney before me, I need to know. If you recall their name, great, we'll write it in. Don't, I will let you know. We'll find that information out. Number 10, 2 things about this. Besides the content of what number 10 says, I will point out that it is shaded in gray. Everything shaded in gray is something that the court is very likely going to ask you in court about. So in this case is, I understand that I have a right to be represented by a lawyer at every stage in the proceedings against me, and if necessary, one will be appointed to represent me. As you know, I have been appointed to represent you. So now I'm going to return to page 1. We've gone through the first 10. In this case, the person circled yes to all of them, filled in their age, their highest level of education, and the initials were there before the first page is complete. Number 11, I have read or had read to me the charging document for the charge or charges against me and have discussed the charge or charges with my lawyer. And now we go to page 2. So in this case, yes is circled on the top, but unlike the first page, you're going to have to draw the circle at the top, put in your initials, and you'll have to draw the arrow down to the bottom. Number 12, I acknowledge that I am charged with. This is something that I will insert into the document. In this example, which is why it's in yellow, this person has been charged with 5 different counts. 13, my lawyer has explained to me the nature of the charge or charges and any lesser included charges and possible defenses that I may have against the charge or charges. 14, I understand the nature of the crime or crimes for which I have been charged. 15, I have told my lawyer all of the facts and circumstances about and all of the witnesses related to the crimes which I am charged and that are known to me, and that I believe my lawyer is fully informed on those matters. Again, it's important that you have told me these things. 16, I understand that the range of punishment for the charges that we had listed before are, and in this case, it's an example. The 5 charges have 5 different ranges of punishment. And each one will be listed, and I will make sure I do list that. 17, I am a United States citizen. Most are, and if you're not, and the answer is no, there are going to be some significant consequences, and then we will make sure that we talk about those. 19, I understand that if I am charged with more than one crime, the punishment on each charge can be ordered to run consecutively, that is, one to be served after another is completed. And while your plea may not have that, it is important that you know that there is a potential to do that if you went to trial. 20, I understand that if I am on probation or parole in this court or in any other court, that by pleading guilty in this case, my probation and parole may be revoked, and I may be ordered to serve a term of imprisonment in the other case, which may be ordered to run consecutively, that is, in addition to the sentence of imprisonment imposed against me in this case. We should have discussed whether or not you're on parole or probation. Absolutely make sure that you have done so. And again, here's page 2, and this is, we've gone through each of these. Person here circled yes for all of them. It was not applicable because they're a U.S. citizen. They circled and initialed their name and went all the way down. Now you're going to have to do this for all the pages. This is the last example I'm giving. 21. Shaded, so the judge is going to ask you about it. Plea of guilty I desire to make in this case is the result of negotiations made by me through my lawyer with the lawyer for the state. 22. If the response to the statement in 21 is yes, and it is because we're entering this plea as a plea agreement, state the agreement. And in this case, you can see the agreement for that person who had faced those 5 charges was they would plead guilty to 2 of the counts. The remaining 3 charges would have been dismissed, and the sentence would be probation. What's important to understand is that everything in the agreement must be written in this part of the document. This is continuation of 22. I understand that the terms of this are, they're either going to be binding on the judge or not binding. And most of the cases, it will be binding, which means if the judge thinks that it should be harsher, she cannot change the plea. The only thing she could do is she could not accept the plea, and then you would not plead guilty. You have a chance to, renegotiate. 23. I understand that I will not be allowed to withdraw my guilty plea if the court does not adopt the recommendations or requests that are non-binding. It's something important the court will read to you, but most of the plea agreements are in fact binding. 24. In entering a plea of guilty to the charge, I am not relying on any promises, agreements, or suggestions made by anyone at any time other than those expressly contained in the above plea agreement. If it's not written in this plea agreement, you are not making a deal to it. 25. I know that the court may accept or reject the above plea agreement, and that if the court rejects the plea agreement, the court will inform me and afford me the opportunity to withdraw my plea. Can't change the plea agreement, but she could say it, or he could say, I just am not going to accept it. And then you withdraw your plea and not plead guilty. 26. I knowingly and voluntarily rejected all plea offers made by the state through my lawyer before the one giving rise to the above plea agreement. In many cases, we will get a plea agreement from the prosecutor that is reasonable, and my clients will accept it. So there will not be other plea agreements. 27. I asked the court to accept the above plea agreement. That is why we are here. Yes. 28. If there is no plea agreement, I know that the sentence I will receive is solely a matter within the control of the judge. I'm not going to read the rest of this because we are filling this document out and you are signing it because there is a plea agreement. 29. I acknowledge that I am not relying upon anyone's promise or representations that if I am committed to the Department of Corrections, either immediately or later, if a SCS or a suspended execution of a sentence, that I will serve less time of incarceration than the time specified in the actual sentence of incarceration that may be imposed in this case. I acknowledge that parole eligibility is determined by the Department of Corrections, not my attorney, not the judge, and not others. This may be the most important paragraph in the entire plea petition. And the reason it is because my clients reasonably ask if they receive a prison sentence now or if probation does not go well, how much time will they actually spend at the Department of Corrections? It is a question which I think is reasonable. I'm willing to talk to you about it. But this paragraph, number 29, wants you to know that the decision about parole eligibility is not something that the attorney or even the judge controls. It's the Department of Corrections. And they do so based on Missouri law and certain policies and procedures that they have established. And so here is a website. It's from the Missouri Sentencing Advisory Commission. And it's a website that they have created to help determine when individuals in Department of Corrections will likely get parole eligibility and have the opportunity to leave the prison. It is based on the current policies and current laws that could ultimately change. And so if you look at this example, here's the statute, and I will type this in, and this is the statute for possession of a controlled substance. And in this case, the sentence could be from 1 to 7 years. And we've typed in that if the judge, in this case, your case, imposes a sentence of 7 years, when would you become parole eligible? Based on current laws and policies and regulations, you would become eligible at 15% of the sentence. So you become parole eligible at 1 year. Each of the laws are different, however. If it's a violent crime, it'll be more time to serve. If you've been in the Department of Corrections before, that could also increase the amount of time that you would serve. And so while I'm willing to talk about this, paragraph 29 is you acknowledging that while we may have talked about it, the sentence that you are getting, in maybe 7 years, is what you are agreeing 30. I have not been mistreated, forced, threatened, or coerced in any manner by anyone to get me to plead guilty. If you have, I need to know and the judge needs to know. 31. No member of my family, friends, loved ones, anyone else has been mistreated, forced, threatened, or coerced in any manner by anyone to get me to plead guilty. 32. I am not now on any medication, nor have I had any drugs or alcohol within the last 48 hours, except as follows. And if you take medication, the real issue is it impacting your ability to understand what you are doing, which is pleading guilty, and what the court is doing, which is sentencing you. 33. I am not now sleepy or drowsy. Awkwardly written, but if you are not sleepy or drowsy, the answer is yes. 34. My mind is clear. 35. I am wide awake and alert. 36. Any medications or drug which I may have taken do not presently affect my mental awareness or my ability to understand what I am saying, doing, or being told. 37. I have never been examined or treated for a mental illness, mental disease, or mental defect, and I have not ever been seen, examined, treated by any doctor, psychiatrist, psychologist, or any other person for a mental or emotional condition, except, and then this is significant, many people get help for their mental health. And if you're getting help and it does not affect your ability to understand the proceedings, we can write in none. 38. I am mentally prepared to proceed with my proposed plea of guilty. 39. I have had all the time I need to talk with my lawyer about the charge against me and what I intend to do about it. 40. My lawyer has fully explained to me the state's evidence and possible defenses that I may have to the charge or charges. Again, if you think there's any question whether or not we have done so, you should not be pleading guilty. We absolutely need to talk about it before you do plead guilty for any offer. 41. I have had all the time I need to talk to my family members, friends, loved ones, or others about the charge or charges against me and what I intend to do about it. 42. I do not need any more time to talk to anyone about this charge or my plea. 43. I understand that while I may receive advice, the decision to plead guilty must be my own. 44. I have made my own decision to plead guilty to the charge and I want to proceed without further delay. 45. My lawyer has fully informed me regarding the following rights that I have under the Constitution and the laws of the United States and the state of Missouri in connection with the charge or charges made against me, and I understand those rights. And this is a listing of rights. The right not to plead guilty and to persist in that not guilty plea, speedy and public trial. The right to be tried by a jury of 12 of your peers. The right to have a lawyer present with you to assist you through any trial. Again, that would be me. The right to confront and cross-examine the state's witnesses against you. 51. The right to decide not to testify in your own defense or otherwise be compelled to incriminate yourself. The right to present witnesses in your own defense. The right to testify in your own defense. And the right to have the state prove the charge or charges against you beyond a reasonable doubt. Each of those, you have those rights, and you do not need to give them up to get this plea offer. But by accepting the plea offer, giving them up. So 55 says, I understand that by pleading guilty, I waive or give up each of the rights listed above that go along with the trial, except I do not give up my right to have a counsel present with me during the proceedings and when a sentence is imposed. And that's why I will be there with you at this plea and sentencing. 56, highlighted, court's going to ask you, I understand that by pleading guilty, there will be no further trial of any kind, because by pleading guilty, I waive or give up my right to a trial. 57. I understand that by pleading guilty and giving up my right to a trial, the judge, not a jury, will impose the sentence against me. 58. I understand that by pleading guilty, I waive or give up any and all constitutional challenges that I may have to the legality of 1. My arrest, 2. Any search and seizure, or 3. Any statement I have made related to the charge. So you're not going to plead guilty if you didn't do it. But for example, if they found drugs in your car and you think the search was illegal, you can still plead guilty, but after this plea agreement, you will not be able to challenge the search that they did that you thought was illegal. The time to challenge that search is before you make a plea agreement like this. 59. My lawyer has shown to me or shared with me copies of the police reports and other documents he or she has obtained in investigating my case. My lawyer has talked to all the witnesses that I have asked him to contact. You need to know who you think the witnesses are and should have done that. 61. My lawyer investigated and discussed with me all of the defenses and other matters which I have asked him to investigate. My lawyer has done everything I have asked him to do on my case. That's 62. 63. My lawyer has not refused to do anything I have asked him to do on my case. 64. No further investigation of this charge by my lawyer is necessary for me to knowingly and voluntarily enter a guilty plea. If you think it's premature to plead guilty because you don't know everything, you should not be pleading guilty. 65. I believe my attorney has been effective and competent in representing me. All of these questions regarding me, you should not be afraid to answer no if you do not believe they are true. I am satisfied with my lawyer's services. 66. 67. I have no complaints whatsoever about my lawyer's services on my case. 68. If I had any complaints about my lawyer's services, I would not be afraid to say so and tell the court about it in front of my lawyer. 69. And you shouldn't be afraid. I'm thick-skinned. It's your rights. You should absolutely tell the judge what you think. 69. I understand that if I have complaints about my lawyer's services, now is the time to tell the court about them. 70. I understand that what I am now telling the court in this petition about my lawyer's services will be used to evaluate any future complaints I may make about my lawyer's services and may serve to completely invalidate such a complaint. Later find yourself in the Department of Corrections and you want to appeal your sentencing. You can say that I am not competent and did not give you adequate representation, but doing so will be more difficult if you say that I was competent and provided good service here. 71, highlighted, it is my decision and mine alone to plead guilty. 72, I have been told and understand that the court will not accept a plea of guilty unless I want to plead guilty. I know that the court will not accept my plea of guilty unless there is a factual basis to support that I did what the state claims I did, that I committed the crime to which I am pleading guilty, and that I am guilty of that crime beyond a reasonable doubt. This is highlighted in gray. Court is going to ask you about it. After the court reads this paragraph and you answer yes, the court is going to ask you to state in your own words what happened on the day of the crime. It is important that you admit the elements of the crime. If they found drugs in your car and the court asks you, did you know the drugs were there? And you say, no, I did not know they were there. The court will not accept your plea. Something that you and I should have discussed in advance. And if you're not able to plead guilty, then we should not have you plead guilty, and you should not do so. So this is where plea agreements go wrong, is at this point where the client cannot admit that they knew they were drugs or they knew the drugs were in their car. If you cannot do that, this plea agreement is not the right thing for you at this moment. Paragraph 74. I have personal knowledge that a factual basis exists to support the state's charge against me. 75. I admit that the state could present evidence to prove beyond a reasonable doubt that a factual basis for the charge against me such that a trial would result in my conviction of the charge. That doesn't necessarily mean that you couldn't win a trial, but you know that the state could win, and that's one reason why people take plea agreements. They don't want to take that chance. 76. I admit that a factual basis supports the state's charge or charges against me, that I committed the crimes which I am charged and to which I am pleading guilty, and that I am guilty of that crime or crimes beyond a reasonable doubt. 77. When the court holds a hearing upon my proposed plea, I will waive my right to remain silent and not to incriminate myself. I will answer truthfully, fully, and completely any and all questions regarding my participation in the crime to which I am pleading guilty. And I will tell the court everything I did or failed to do which proves I am guilty of the offense to which I am pleading guilty. 78. I know that the court will not permit anyone to plead guilty who is innocent, and that with that in mind, and because I am guilty, I wish to plead guilty and respectfully request the court accept my plea of guilty. Paragraph 79. I have read this entire petition or had it read to me in its entirety, and I understand it. And when I finish paragraph 81, I will have read it to you in its entirety. Number 80. My lawyer has discussed with me each and all the representations that he will make to the court contained in the certificate of defense counsel at the end of this petition, and I will. 81. If any of my responses in this petition change between the time I sign it and the plea hearing is held in the court, I will tell my lawyer and the court of such a change before pleading guilty. So, for example, if no one has twisted your arm or threatened you prior to this point and you sign it, but later someone does threaten to you, the court absolutely needs to know, as do I. And here's the final page of plea petition that you will fill out. Again, all the yeses will have been circled. You'll have a circle here with your initials and a line down. Then you'll date and sign, and I will sign watching you do so. 8th page, the prosecutor says, I agree with this offer that I've made. And then here is the final page, which is my certificate of defense counsel. And we're going to go through each of these because it's my obligation to tell you what I'm representing to the court. So it starts off with the undersigned as lawyer and counselor for the defendant hereby certifies to the court that, and there's 12 paragraphs. Number 1, I have read and fully explained to the defendant the allegations contained in the charging document for the criminal charge or charges referred to in this petition. Number 2, I explained the applicable range of punishment for each of the crimes charged to the defendant. Number 3, and this relates to the earlier paragraph 29, which is, although I did discuss the issue of parole eligibility with the defendant, if the sentence is to be imposed immediately or if there is a suspended execution of a sentence, I made it clear that the defendant cannot rely upon anyone's promise or representation that if committed to the Department of Corrections, the defendant will serve any less time of incarceration than the time specified in the actual sentence of incarceration that may be imposed in this case. I explicitly informed the defendant that parole eligibility is determined by the Department of Corrections, not by any attorney, judge, or others. The example that I had given you was that someone who is facing a 7-year sentence for a non-violent drug offense needs to know that they are agreeing to 7 years, even though the policies and procedures at that moment means he could be eligible for parole at 15% or 1 year. 4. There have not been any plea offers made by the state that I have not conveyed fully, completely, and timely to the defendant. That's my obligation to tell you all offers, and I have done so. 5. To the best of my knowledge and belief, the statements, representations, and declarations made by the defendant in this petition are in all respects true and accurate. I've told you to tell the truth to me. 6. My initials next to the defendant's on each statement in this petition indicates that I have discussed the statement with the defendant and that his or her indicated response, either the yes or the no, is in accord with the defendant's intended response as stated to me in those discussions. 7. The plea of guilty offered by the defendant is in accord with my understanding of the facts and the defendant related to me and is consistent with my advice to the defendant. 8. I have investigated the circumstances of this case and have explored all avenues respecting the facts relevant to guilt and the degree of guilt or penalty. 9. I have made appropriate efforts to secure information in the possession of the prosecution and law enforcement authorities. 10. I have investigated potentially relevant collateral consequences of this plea, including, or but not limited to, deportation and other immigration issues, that's if you're a non-U.S. citizen, the requirements regarding sex offender registry, sex offender treatment, and potential civil commitment for sex crimes, limitations on possession of firearms, limitations on the exercise of civil rights, and possible limitations on probation and parole eligibility or conditions. If any of these potential consequences apply to the defendant, I have appropriately advised the defendant. 11. In my opinion, the plea of guilty offered by the defendant is voluntarily and understandingly made. I recommend that the court accept the plea of guilty. And 12, I have discussed with the defendant all of the representations I am making to the court in this certification. And with that, what I would like you to do is note the paragraphs that you need to discuss with me in greater detail. I want you to call or text or set up a meeting, and we can absolutely do that. Last resort, we can talk about it the morning of court. That's not preferred given how crazy it is, but it is critical that you understand every single paragraph that you are circling yes and initialing. I'll see you at court.